rise. The Court of Appeals Division 1 is now in session.
Please be seated. Don't have. There we go. This is the time set for oral argument in 1 CR 210138 State versus Preston. And counsel, I'll alert you that we have conferenced this case in conference this morning. We've obviously read your briefs. We're familiar with the issues. Please state your name on the record before you begin. And with that, you may begin.
May I remove my mask during this argument?
May.
Thank you. Good morning. Elizabeth Garcia on behalf of defendant Samuel Clayton Preston. Present with me at council table is Lori Vopel. I'd like to reserve about 5 minutes of my time for rebuttal. I believe our opening and reply briefs adequately discuss the errors that require reversal of Sam's convictions. But in the 20 minutes allocated today, I'd like to focus on 4 of those issues. The failure to give the requested Willits instruction, the erroneous giving of the molestation, lesser included offense instruction on count 2, the violation of Sam's due process right to present a complete defense, and the cumulative prosecutorial misconduct. Of course, if this court has any questions about the denial of the violation of Sam's confrontation rights or the trial court's consideration of improper sentencing factors, I'd be happy to address those questions as well. At the outset, I'd like to emphasize that in reviewing the denial of a Willits instruction for an abuse of discretion, we have to view the evidence in the light most favorable to the proponent of the instruction. And in this case, that's Sam. So any hypothesis that the state may have about, well, Sam could have showered, or he could have washed his clothes, or, the less than 24 hours that passed between the alleged encounter and his interview somehow.
I thought the test was what is obviously recognizable by the government in securing the evidence.
Correct, but in viewing the evidence, in making that assessment about whether the evidence was obviously material, we have to view the evidence in the light most favorable to the proponent of the instruction.
In this case, didn't he specifically tell the investigating officer that there would be no DNA on him because he didn't do it?
Correct, and so that goes to show that the absence of DNA on his body would have been obviously material to the officer because he knew that Sam's defense would hinge on the fact that
So where was the officer supposed to swab? Since he said, there's nothing on me, so just do an entire body swab. Just get naked and we'll swab your entire body.
No, that wasn't required because by the time the officers interviewed Sam, they'd already spoken to KF. So they knew what actions had been alleged. They knew the hands had been alleged, right? That she had alleged Sam had made her rub his penis by putting his hand over hers, that he had rubbed her vulva, penetrated her vagina, and rubbed her left breast. So they knew hands had to be swabbed. They knew his penis could be swabbed, and they knew his boxers, which she claimed that had been on him during the encounter, would also have held DNA. And how do we know that those areas of the body and the clothing would have held DNA? Well, by the evidence. Viewing it in the light most favorable to Sam, it established that non-smooth surfaces, like the hands and clothing that he was wearing, would have been more likely to retain DNA. We also know that it establishes that rubbing, the action that KF alleged occurred, is more likely to leave DNA behind.
But are you saying that it's the most favorable in hindsight, 2020, from the police officer's perspective? That's the test? Because it seems to me that we're talking about a frontline officer who's supposed to be gathering evidence, that it's supposed to be obvious to him or her at that moment in time.
Correct, at the time of the investigation. We don't look back and question the viability or the strength of the evidence in hindsight. At the time that Sam was interviewed, what do we know? We know Detective Sedlasek admitted DNA is important to my job. DNA, he studied DNA, tried to keep up on its advancements. We know that transfer DNA is the rule, not the exception, and that there are hundreds of publications, forensic and medical, that address transfer DNA. This is not a new concept that the detectives would have been unaware of. What else do we know? We know Detective Gray admitted, there's no reason I wouldn't want to collect Sam's boxers, right? Why didn't they collect this evidence? Because Detective Sedlicek gave us that answer, because he didn't include it in the warrant request. And if he wanted to collect this evidence, he would have had to obtain a revised warrant. Sam shouldn't have to bear the burden of the detective's refusal to obtain a revised warrant for evidence he acknowledged was relevant, that he knew would be important to Sam's defense. And let's not forget Detective Sedlicek's interview questions to Sam. What did he say? Sam, every time you touch something, there are two things that happen. You leave something behind, you pick something up. There is no question that at the time they interviewed Sam, the police were fully aware that the DNA evidence they did not collect from Sam's penis, hands, or clothing was obviously material. They knew DNA could have been picked up and it could have been transferred.
But in this case,
yes.
do we have it, given the fact that they acquitted him of all of the counts that didn't have DNA, isn't it harmless?
No, and I would also urge that the state hasn't argued harmlessness, so it's waived that contention. But even if it hadn't, the evidence on KF's external genitals wasn't limited to Sam. It matched all his male, paternally related male relatives. That included the son, who, like KF, had dried himself with a used towel hanging in the Preston's bathroom. Had there not been substantial evidence of transfer DNA, which was established here, our analysis might be different. But again, we have to view the facts in the light most favorable to Sam, the proponent of the instruction. Detective Sedlicek knew that Sam had worn at least one piece of Tori's clothing at the time they interviewed Sam. There's multiple mechanisms by which DNA could have transferred to her external genitalia and her left breast. Putting Sam's hat under her shirt while they were roughhousing, that sweatband, we know, contains DNA. She could have gotten it from the towel, the used towel that she dried herself with, which could have contained both Sam's and his son's DNA. She also could have gotten that by wearing Tori's used clothing after the egg fight. So there are multiple mechanisms. The DNA that was found on the external genitalia that relate to all of Sam's paternally related male relatives isn't overwhelming evidence of Sam's guilt when the record establishes that there were substantial ways that it could have transferred to KF's body. And the same is true of the DNA on the left breast. It also could have been transferred to her body through these mechanisms. Sam was forced to bear the burden of the state's refusal to collect DNA that it knew would be relevant, that was obviously material, and that would have been exculpatory. Had the DNA results come back, we know that the left breast swabs didn't all come back positive. Only some of them did. We know that the DNA on the external genitalia wasn't limited to Sam. So had Sam's swabs come back negative, that would have been powerful evidence that KF's story was not true. And he was deprived of presenting that defense because the detectives didn't want to get a revised warrant that included the DNA swabs that they knew were they could have taken. And another point I'd like to make is the state hasn't disputed, and the record wouldn't support this argument, that the evidence wasn't reasonably accessible. We know that when they interviewed Sam, the detectives had the means to collect swabs from him. The only thing they didn't do was get that revised warrant, which would have allowed them to obtain these swabs. Okay. So finally, I'd like to address that prejudice prong relating to the Willett's instruction. Contrary to the state's assertion otherwise, Sam doesn't need to show that the denial of the instruction itself was prejudicial. That's a separate prejudice showing that would be required under fundamental error review. We're not under fundamental error review. We review this error for an abuse of discretion, which means that the prejudice Sam had to establish was prejudice, resulting from the state's failure to preserve the DNA evidence. And he satisfied that when he established that his right, his ability to present that complete defense and that powerful exculpatory evidence was, he was prevented from presenting it by the state's failure to preserve that DNA.
But counsel, I'm still having a hard time understanding how that evidence would have tended to exonerate him. So please.
Yes, absolutely. So we know hands are more likely to hold DNA because it's a non-smooth surface. The rubbing that was alleged would have been more likely to leave DNA had that contact occurred as alleged. We also know that even if he had washed his hands, DNA could still have been recovered from under his fingernails. Had his hands come back completely clean of all of KF's DNA, that would have been powerful evidence that he never touched her vulva, he never touched her left breast, and that the alternative mechanisms by which his DNA could have transferred to her were in fact the only way that it could have transferred to her, which would have required an innocent verdict, an acquittal on all 5 counts, and not just.
Required an acquittal. Absence of DNA is never, you don't get a dismissal of a criminal charge for absence of DNA.
No, forgive my terminology. When I say required, I think it's the jury would have been more likely to render an acquittal on all counts. We know that the jury didn't find KF's testimony sufficiently credible to warrant a conviction, standing alone. So based on this record, had the swabs of Sam's hands come back clean of all of KF's DNA, and the same is true for the swabs of his penis or boxers, had they been conducted, we know that this jury wouldn't have been willing to convict Sam.
We don't know that, though, do we? All we know is they weren't willing to do it if his DNA wasn't located where she said he touched her. But we also know that if the DNA was there, on all the DNA counts, he was convicted. At best, your argument is, well, there's at least a chance the jury might then have decided to believe the defendant instead of her.
The jury wasn't willing to render an outright conviction on count 2, where there was DNA on KF's external genitalia. They didn't want to render a guilty verdict on the sexual conduct charge. That's why they convicted him of the molestation charge, the lesser included offense.
But it still involved physical contact with her exterior, the exterior of her vulva.
The mere presence of DNA wasn't enough for the jury to say he is absolutely guilty of the offense as charged. And so Sam, the burden of proof to show that evidence is potentially exculpatory, Sam doesn't have to show that he absolutely would have gotten an acquittal. We have to show that that outcome was likely, and on this record, where the jury's other verdicts give us insight to what they found persuasive, we can say it is likely they would not have convicted Sam of the lesser included offense on count 2 and of count 5 had there been this exculpatory evidence that contradicted KF's version of events.
I guess I'm still struggling with the notion that he says, nope, I don't have any, there's no DNA, her DNA is not on my hands, or whatever. It wasn't, that's not exactly what he said. And then we were going to fault the police for nonetheless swabbing his hands. Not swabbing his hands, I misspoke.
Correct. The Willits instruction is given so that the defendant doesn't have to bear the burden of the state's failure to conduct a complete investigation.
That's not bearing the burden. That's them believing what he said. He says, oh, I didn't touch my hand, so.
We don't know that the detectives believed what Sam said. They swabbed KF and submitted that DNA, those swabs for testing. They knew that his defense was that there would be no DNA. Otherwise, the Willits instruction, if that were true, if a defendant's denial of the accusations against them were sufficient to relieve the state from all responsibility for conducting a complete investigation, the Willits instruction would never be available where a defendant denies the charges against them.
That's not true. He specifically said, I did not touch her.
Correct.
So they didn't swab his hand.
Correct. And she said, he did touch me. He committed all these acts that consisted of rubbing my genitalia and my breasts.
And so they swabbed her.
They swabbed her, and they didn't swab him, even though they knew that if the accusations were true, the DNA would have appeared on both.
But then you're going back to what is the standard that we're going to judge law enforcement here, and I just don't think it is that standard that they're supposed to be perfect. And if they're not perfect, then we're going to tell the jury to hold that against them in the fashion that Willits requires.
The standard is, was the evidence obviously material, right? Did the state use this evidence in its investigation? Did it know that Sam was likely to also rely on this evidence in his defense? Yes, it did. It knew that because he denied that any DNA would be found on him.
But you got the benefit because you presented all of this evidence to the jury, and the jury just rejected it.
The state also argued and shifted the burden to Sam, saying it was on him to present the police with his boxers. The state's argument counteracted Sam's closing argument. Did he address these issues and concerns in closing? He did. But the state's counter-argument and the court's instruction to the jury that what the attorney said was not evidence it could consider and that it was to follow the court's instruction mean that the denial of the Willits instruction wasn't harmless. The Willits instruction, as the Arizona Supreme Court has recognized, is a very powerful tool. Without that instruction, that there is no way this jury would have drawn an inference, particularly one as powerful as the one permitted by Willits, that the Arizona Supreme Court has recognized alone can create reasonable doubt. And so any closing argument wasn't sufficient to remedy the prejudice from the state's failure to preserve the DNA evidence and any, or the court's failure to issue the instruction itself. I see I have 4 minutes left, so I'd briefly like to touch on the lesser included instruction on count 2. That's the second reversible error we addressed in our briefing. That lesser included instruction was not supported by the evidence. Sexual conduct requires proof that Sam intentionally or knowingly penetrated or engaged in masturbatory contact with KF's vulva. And as explained in the briefing, count 2 was based on that masturbatory contact with KF's vulva. So the question is, was the contact that KF alleged occurred masturbatory contact, or could it be construed as, for lack of a better word, mere touching, fondling, or manipulation? On this record, and in this context, that contact cannot be construed as anything other than masturbatory contact. And it's an analogous count is the masturbatory contact with the penis that was charged. The testimony KF gave on that count was very similar. It was rubbing. It was only a few seconds, right? The temporal, the duration of the rubbing didn't shift it into the molestation or lesser included.
But can't the jury decide that shifted it? It was only a few seconds. The jury can decide based on the definitions that it wasn't sufficient in their mind to constitute masturbation, but it was in fact touching.
It doesn't have to be masturbation, it has to be masturbatory contact. So the duration really doesn't characterize.
But isn't that what makes it a lesser included offense? Because all we're doing is taking the word masturbatory out, and then there's contact. And the jury could find, yes, in fact, there was contact. It just wasn't masturbatory.
The type of contact that occurred here could not be described as anything other than erotic stimulation. So it can't be characterized as a mere touch.
Well, in your opinion, but the jurors can assess the evidence differently, correct?
The juries could assess the evidence, but they should never have been given an instruction if there wasn't evidence that supported that a mere touch had occurred. KF consistently said that rubbing of the vulva was what had occurred here.
Are you saying that the state could not have just charged the lesser offense?
Had they chosen to, they could have, but on this record, they charged masturbatory contact.
Okay.
And the giving of that lesser included instruction, particularly when combined with the prosecutor's closing argument, inviting the jury to convict Sam of that lesser included offense, if it had trouble deliberating, really moved this into, a prejudicial error that deprived Sam of kind of the benefit of the defense that he had to that charged offense. And I see I've only got 1 minute and 30 seconds left, so I would like to reserve that for a brief rebuttal.
All right, thank you, Ms.
Thank you.
Mr. Valenzuela.
May I remove my face mask for the?
Oh, please.
Thank you. Good morning. May it please the court. My name is Michael Valenzuela. I represent the state of Arizona. May it please the court. The jury in this case heard the evidence that it was entitled to hear, consistent with the law that it was entitled to hear. After carefully scrutinizing the counts charged in this case, it convicted Preston on some counts, but it acquitted him on the majority of the counts. The reality of this case is that based on the record and the law presented, Preston received a fair trial, and for that reason, this court should affirm his convictions and sentences. Pointing quickly to the Willits argument, I think it's important to note that Hernandez sets forth the test on what we're supposed to look at in determining whether evidence is obviously material. And this is a test that's focused not on what would have been reasonable in retrospect, but what was actually before the officers at the time of their investigation. And here, the officers evaluated the evidence. They had the story from the victim in this case, and they determined at that time that the best way to investigate this case was to swab the victim. So that was the evidence that the state decided to rely on. And under Hernandez, we look at two things. Was the evidence that the state was going to rely on, or was it evidence that the state knew the defendant was going to rely on? Well, to that second prong, the state didn't know the defendant was going to rely on this evidence because when it interviewed Mr. Preston, as Judge McMurdy pointed out, he gave them no basis to believe that swabs of his body would be important to differentiate what the results would be from the victim versus whatever may have continued to rely on him. They asked him whether anything would be found on the victim, and he stated that no, he didn't touch her, nothing would be found. Preston later at argument presented...
Doesn't that cut both ways? I mean, they're swabbing the victim, so they're obviously checking out that part of the story. But why wouldn't they just swab the hands? I mean, it's right there, it's very easy.
I think that's a valid criticism of the state's case at trial, and it's something that Preston really hammered home throughout his examinations of the state's witnesses, his examination of his own expert DNA witness. It's something that he used in closing to repeatedly attack the state's case, and those attacks landed. The jury ended up acquitting Mr. Preston on any of the counts that would have related to her DNA being found on him. Count one would have been the forced masturbation on Mr. Preston. The swabs of him would have been, more relevant onto that count than the two counts of which he was convicted, and he was acquitted on that charge.
Counsel, how does the passage of time we have here from the time the incident occurred to the time, the police would have been able to swab him, how does that affect the analysis?
Well, it affects the analysis in terms of looking at the officers and what their mindset is at the time of the investigation. Officers don't conduct their investigations in the absence of common sense. And so while Mr. Preston points to a lot of testimony that was later developed at trial about the plausibility of evidence remaining on him during that time, what the officers knew at the time was that it had been over 24 hours since the molestation event, between that event and when they interviewed him. At the same time, Mr. Preston wasn't in police custody throughout that entire time. He, for a large part, was not around. The record develops that after the victim's dad learned about the incident, he went over to confront Mr. Preston. Mr. Preston wasn't at home, and I believe the record reflects that when the police went over and made their initial contacts with the victim in this case, Mr. Preston wasn't home. And so we not only have the passage of time, but we have that coupled with no clear indication that Mr. Preston was in a controlled environment where this evidence could have been collected. So I think these are considerations that the police had in their mind at the time of their investigation, and it weighs toward their determination of whether or not relevant evidence would have existed.
So let me just make sure I understand, because the question is whether or not the evidence was obviously material, reasonably accessible, and could have a tendency to exonerate the accused. We'll set aside the prejudice. It seems to me you're not disagreeing. There's at least the evidence might have had some tendency to exonerate, not conceding that it would have, but might have some evidence, the absence of DNA?
Well, no, I don't concede
Okay.
I don't concede that point, and I think that this case is really on fours with Hernandez and their discussion of the significance of DNA and really the notion of the absence of evidence being the evidence of absence.
You don't disagree, Bobby, I'm sorry to interrupt, but you don't disagree it would have been reasonably accessible?
We did not challenge the reasonably accessible in our
Isn't
briefing.
the real issue here, and I just kind of circle back to where I was headed, which is, I think the real issue is after 24 hours, is it obviously material to take a DNA sample? It seems to me that's where your argument is. And is it an abuse of discretion for the trial court to have said, I don't think this was obviously material?
That's correct. I think a large portion of the argument rests on whether it was obviously material, and as our Supreme Court has guided us on that analysis, we look at whether the police relied on it in their investigation. That would have been a situation akin to Perez, where the police are looking at a videotape with the witness, and then they allow that videotape to expire. Well, that's not the case here. And then the second prong would have been whether the police knew the defendant would rely on that evidence. And I would just point you back towards the recorded interview of the defendant and the question of him, and I think it's not an abuse of discretion looking at that the police didn't believe he would rely on that evidence at that time.
How long, from the time of the alleged incident to when they swabbed the victim, how long was that time?
I believe it was a couple hours, possibly 4 or 5 hours, but a large portion of that time was also the victim was in not police custody, for lack of a better word, but they were accompanied by police. The police took her down for an interview. Correct.
As I recall, once the father got home, they pretty quickly called the police.
Correct.
And then the daughter was pretty quickly interviewed. And from that point on, she was either with her parents and or the police.
That's correct. And just to wrap up on this Willits issue, I think it's important that, in terms of the impact on Mr. Preston, he didn't bear the burden of this, because at the end of the day, he presented a very persuasive case in attacking the state's investigation. And really, what a lot of his argument goes back towards is the failure to investigate. It's that the police could have investigated this, but they didn't. And our Supreme Court has cautioned us that that's not the function of a Willits instruction. It's not to criticize the police or to argue that a more extensive investigation could have been done. Those are arguments that are best left to the jury, and in fact were persuasively given to the jury in this case, as evidenced by the acquittals.
I have a question. It doesn't deal with Willits. Are you ready to move to the next question? At sentencing, it seems to me that Judge Ryan specifically considered lack of remorse. And it's not the lack of remorse where the defendant's out celebrating the crime. The lack of remorse in not taking a plea agreement. Isn't that a clear violation of constitutional rights?
Well, in the abstract, a judge considering that would be a violation of constitutional rights. But based on the record here, I would contest that Judge Ryan inappropriately considered that factor. When you look
He did
at,
or did not? I thought you said, did you say he did consider?
He did not consider that factor. I'm sorry. When we look at the record in this case, there's the discussion of the prior plea agreement that was offered to Mr. Preston before trial. And under that agreement, he would have received a lifetime probation term with no prison time, and he rejected that. And so a lot of the judge's comments reflected back to that. And, I think really significant in looking...
Not to, split hairs here, but if he's discussing it, isn't he, by definition, considering it?
I would not say that the mere discussion of it would mean that he's considering it. He's loosely talking with the...
He's explaining the sentencing options available to him, and the reason why he's picking one sentence over another, and he mentions in great detail the fact that there was this plea offer. And he wanted to make sure he had it right, so he even asked for what it was, and went on and on and on. what more does he have to say I guess he could have said, I am hereby considering it, but it sure looks to me like he was considering it.
The comments certainly are inartful, but I think we also have to listen to the judge when he says 3 times during sentencing that he's not considering it. I can point to the portions of the record where that's made, but we have on sentencing, page 23, the judge agrees that he can't consider this in sentencing. Again, later on page 25, he says that he's not going to punish Preston for invoking his right to invoking his innocence rights and going to trial. And again, on page 26, the judge states that he doesn't want Mr. Preston to think that he's punishing him for going to trial. And so at a certain extent, when we have a muddled record like this, I think the court has to give credence to the judge affirmatively stating that he's not considering these things in sentencing, and give deference to those, particularly here where there was no contemporaneous objection to those statements. I think the lack of an objection is reflective of defense counsel's mindset that these aren't some things that were being improperly considered.
The comment about, I think the woman did protest too much. I mean, if he said it 3 times, it seems to me like he was adamantly aware of the fact that it looked like he was considering it.
I think that if you look at the record and those statements in isolation, they do look pretty. They do look pretty negatively in terms of whether he considered it. But when you consider that along with his affirmations that he's not considering that, and in making those same comments, he makes a comment to Mr. Preston that you could have been serving no time. Well, that's certainly not an option that was before the judge at the time of sentencing. So I think that just further indicates that this is something the judge was he was thinking about this in his head in terms of, this is a situation that he had a favorable plea before trial, but that's, as he states on the record, that's neither here nor there now. Ultimately, I think it's also important that we had the finding of, when the judge actually gets around to orally explaining what the mitigating and aggravating circumstances were that he considered, you had some aggravating circumstances, you had some mitigating circumstances, and the judge, in weighing those, landed on the presumptive sentence. And so
in weighing those, he affirmatively said, I'm not considering the absence of remorse. Right at that point, he said, I'm not considering that. He
said it right around that time, yes. I don't think he said it in the midst of stating those factors, but it was soon beforehand. And the fact that the court weighed some mitigation, some aggravation, and landed on presumptive distinguishes this case from many of the cases that Preston relies on in his appellate brief. In those cases, a better case was made that the judge had improperly considered that factor because the judges in those cases landed on aggravated sentences. Here, the court did what it was presumptively supposed to do when it had some.
Wait a minute. There can be error. He landed on a presumptive sentence. But if he had said, in aggravation, I find all of the things and lack of remorse, the fact he landed on the presumptive doesn't isolate the error involved, does it?
I think that would be true where he's explicitly stating it in his consideration of aggravating and mitigating circumstances. But that's,
so it's not where he landed; it's the fact whether or not he considered it.
Well, I don't believe that the mere stating of that on the record presumptively proves error. I think you have to consider the entire circumstances surrounding the sentencing discussion.
Counsel, I have a question about the precluded testimony from the 2 juvenile friends. So I was wondering if you could kind of point to me where in the record did the court actually preclude that evidence? I mean, the parties acted as though the court did, but in the minute entry, it doesn't seem to explicitly preclude that evidence.
Well, I think as I identified in my briefing, it's a little bit unclear. The court does issue a minute entry ruling, but then there's later discussion at one of the hearings that's referring to some sort of further discussion on the issue that was neither on the record or in the minute entry. But there was I think an understanding of what the ruling finally landed on in terms of precluding them from testifying about this hearsay testimony and this testimony of the other acts that had happened to the two other witnesses.
So based on that, would the defense been able to question the victim about her friends' or about the incidents her friends had experienced?
Sure, it's conceded. The state conceded in the initial hearing on the matter, in the oral argument on that matter, that it had no problem with him asking the victim about what she knew, as long as she didn't go into the specific hearsay details of the other witnesses' encounters.
And did the defense ask the victim that question?
He did not.
But just so I can understand that procedure, the defense attempted to ask the defendant's wife about some of that, correct?
He attempted to ask the defendant's wife what she had heard from other people, and so if my recollection is correct, it was both an objection on the basis of the ruling, but it was also hearsay as well. But as Judge Payton pointed out, I believe that the best avenue for him to develop this would have been through asking the victim in this case about what she knew and how it may have impacted her, because ultimately there was just a speculative link between the incidents that these other witnesses may have suffered and how it influenced the victim in this case. There was really, even looking at the offers of proof that were made at the oral argument on the case, it was just kind of assumed that because she had heard the other girls talking about this, that she was going to fabricate these allegations. And as
But
the
wouldn't
state,
it be difficult to make an offer of proof if you haven't had the opportunity to interview those
well,
two
he
witnesses?
interviewed one of the two witnesses, a witness with the initial RA.
Okay.
He did interview. It was the other witness, SH, that he was unable to interview. And, I think conceivably after developing this issue more through the testimony of the victim, he could have reasserted his ability to present this argument.
But he couldn't interview the victim.
He couldn't interview the victim, but he could have asked her the questions at trial. And, of course, the witness RA, he did interview and at least had some basis from her on that account. But at the end of the day, we still have the speculative link between something happening to these other witnesses and the allegations in this case. And I think it's important to note that the allegations here, they weren't the type of sexual knowledge that, distinctive sexual knowledge where hearing it from somebody else may have contributed to the victim here learning the information needed to make the allegations here. The allegations here were the type of good touch, bad touch allegations that are within the realm of a 12-year-old child. And so, nothing in the allegations pointed to knowledge outside of, a specialized knowledge or a certain level of naivety that would have further added to the relevance of the other acts that these other witnesses may have encountered.
Counsel, how do you respond to defense's Preston's argument that the prosecutor actually violated that preclusion order in closing argument?
Well, I don't believe that he violated the preclusion order. When he's talking about the ability of the victim to, make her story, it's not relating to sexual naivety or needing to learn this information from somebody else. The prosecutor has tied in those arguments with the testimony about the DNA and about the feasibility of the victim not only to come up with the allegations she made, but also know that there was going to be DNA on her body to corroborate those allegations and her knowledge of transfer events and how to transfer that DNA and the plausibility of Mr. Preston's defense that the DNA had been transferred there through these multiple transfer events. If the court has no other questions, I ask that you affirm Mr. Preston's sentences and convictions.
All right, thank you
Thank
very
you.
much. Ms. Garcia, you have almost a minute and a half.
Yes. I would urge this court to reject retrospective speculation about what the officers might have thought at the time they interviewed Sam. We know what they did think based on their testimony. Detective Sedlicek didn't fail to collect the DNA from Sam because Sam denied touching KF. He didn't collect it because he didn't want to get a revised warrant to collect that DNA. Detective Gray also admitted there was no reason, not 24 hours, not the passage of time, that he wouldn't want to collect Sam's clothing and boxers to exclude him as a potential suspect. Their testimony is dispositive of what they thought was obviously material at the time they interviewed Sam. The totality of the errors at trial, which included the preclusion of evidence explaining why KF came up with these very specific allegations, specificity that the prosecutor highlighted in closing, deprived Sam of a fair trial. And I'd like to note, Judge McMurdy, you addressed the preclusion of the testimony from KF's mother. It wasn't precluded as hearsay. It was precluded because the court thought that by trying to adduce that evidence, Sam was going beyond the bounds of what had been permitted by its earlier ruling. Accordingly, Sam respectfully requests this court vacate his convictions and sentences and remand for a new trial. Thank you.
All right, thank you. The case is deemed submitted. We'll issue a decision in due course. We'll now set up the courtroom for the next argument. We are in recess.